Good morning, everybody, and a very warm welcome to this webinar on the very crucial issue of how the criminal law should respond to the perpetrators of gender-based violence. And we are delighted to have Advocate Dellene Clark with us this morning. She's an expert in the area. She serves on many important panels and works to ensure that the legal processes behind the scenes, so to speak, work well.
Good morning, Father Pearson and all the participants. Thank you for this opportunity of sharing the Commission's issue paper on domestic violence and criminal law response with you today. I've really been looking forward to this engagement, and I think it will be a fruitful dialogue once I've done the presentation. So just in order to place the issue paper in context, and I will flight my presentation shortly, I'll just be giving a brief overview of the role of and processes conducted at the Law Reform Commission, and then give you an overview of the issue paper, which will also include a reflection on some of the latest amendments to the Criminal Procedure Act and also to the Domestic Violence Act. So if you'll just give me a second while I upload the presentation, please. In terms of the Law Reform Commission, the Law Reform Commission is a statutory body that is housed within the Department of Justice. And the mandate of the Law Reform Commission is to do legal research into identified areas of the law with a view to develop, improve, and modernize and reform the law. If I could place it in a nutshell, what we essentially do is to review the existing law, reform law when it is needed, and then anticipate the need for new law. And that is what we'll be looking at this morning. The President appoints commissioners to oversee the program of the Commission, and currently it's chaired by Justice Collopin. And the two commissioners that have been assigned to this investigation to oversee it is Professor Domingo and Advocate Mankies, previously of the National Prosecuting Authority. The Secretariat is staffed by state law advisors and specialist state law advisors, of which I'm one, and we're seconded from the Department of Justice to man the Secretariat and do the research, and we're ably assisted by expert advisory committee members. Now, the aim of the Law Reform Commission, as I said, is to develop, improve, and modernize the law. And two of the more well-known laws that have originated from the Commission are the Children's Act and the Criminal Law Sexual Offences Amendment Act of 2007. And the Domestic Violence Act, which reviewed the Family Prevention Act of 1992, was also birthed at the Law Reform Commission, just to put that into context. So I've been with the Law Reform Commission as a researcher for just over 2 decades now. And I hope that doesn't date me too much. So in terms of the processes followed, experience has shown that to be effective, law reform should be backed by extensive research and public consultation. We receive requests to investigate the need for law reform from members of the public, from government, and from Parliament. It's not only housed within the Department of Justice. In terms of our requests, we will, once we've received a request, conduct a pre-investigation, and that pre-investigation will then serve before a sitting of the Commission, who, if they deem it necessary to place it on the program, will recommend that to the Minister of Justice. And if he then places it on the program, a researcher will be assigned and an issue paper will be developed. And that's where we are at right now with this process. So it's published right at the beginning of the investigation to start the process, and it's followed by public consultation, which we're embarking on now. The issue paper identifies key issues, and it provides an overview of the current law and also a brief comparative overview. Once the consultations have been completed, we compile a discussion paper, and this contains the comment that was given on the issue paper and also other additional information which we have gleaned from our consultations. It will then also contain the Law Reform Commission's tentative proposals for law reform, so it may include draft legislation. We then embark on another round of consultations, and that will then bring about a report, which is usually accompanied by draft legislation. And the comment, once again, either by way of verbal or written comment, is then incorporated into the report and handed to the Minister of Justice. And if it doesn't fall within his portfolio, he will then send it on to the relevant minister, who will then consider whether they wish to incorporate the law into a legislation or not. So as everyone is sadly well aware, we have a very unacceptable level of violence, not that violence is ever acceptable, but an unacceptable level of violence against women and children in South Africa, and sadly worldwide. The President has been very vocal in his support of addressing gender-based violence and femicide in our country. And he's acknowledged the number of barriers that are to eradicating it. And some of the statements ascribed to him in a dialogue on gender-based violence in 2020 are that South Africa is in the grip of a relentless war being waged on the bodies of women and children. Further, that violence perpetrated by men against women is the second pandemic that our country must confront. And then thirdly, that the fight to end gender-based violence is both simple and highly complex. And I think of those in the room, you would know that it is highly complex. There's no one size fits all. So this brings us to the discussion on the issue paper. And just in terms of the aim of the issue paper, the aim is to review the criminal law response to violence perpetrated within domestic relationships and interpersonal relationships. Firstly, to determine what the current criminal law response is, whether the criminal law response is adequate, and then thirdly, if it's not adequate, whether there's a need for law reform or non-legislative recommendations to address implementation problems. So when one looks at the problem or the theory of change, three main areas have been highlighted with regards to the criminal law response and the response to gender-based violence. Firstly, that there's a failure, that the failure to prevent and protect women and girls from domestic violence constitutes grave and systematic violations of rights under the Convention on the Elimination of Discrimination Against Women. There are high levels of violence which continue in spite of the current law, and there are high levels of secondary victimization which also occur in spite of the current law. The response by the criminal justice system has been found inadequate. And finally, the ripple effect on a societal level with normalization of domestic and sexual violence in a culture with high levels of interpersonal and sexual violence against women and children expose women and children to further violence and models a lack of compassion for survivors. The high-level panel that was appointed by the President and the United Nations Committee on CEDAW have found that there are a number of barriers in our country to preventing violence. And the first is that domestic violence is not a specific offense. Secondly, that it's difficult to collect data without a specific offense, that there is lack of enforcement of the law by the police, and there's lack of capacity building and awareness raising for the judiciary and the police. And they've made a number of recommendations. And these are firstly to specifically criminalize domestic violence or identified elements thereof, to establish penalties that reflect the gravity of all forms of domestic violence and femicide, which is the murder of women. And thirdly, to introduce what they call ex officio prosecution, so automatic prosecution. However, they do put a rider in place, and that is that the court should be able to issue a final warning rather than sentencing if the complaint is withdrawn on reconciliation. This brings us to the second element that has been identified as a problem, and that is that domestic violence offenders are not held accountable to the same extent as offenders of other or similar criminal offenses. I have put a question mark here though, because recent judgments that have been in the media have reflected otherwise. with an attorney being given 2 life sentences for the strangulation and rape of his wife. These are, however, the more severe cases that are getting the higher penalties. I do see that my screen, as it is enlarged, has cut off the third problem. So I'm going to just reduce so that you can see it. And that is that the danger of strangling or choking may be overlooked or addressed by way of trivial charges. And I will expand on that just now. So as I said, these are the 3 questions that we are posing is, firstly, what is the current criminal law? Is it adequate? And is there a need for law reform? So in terms of our current law, I'm going to give a quick overview of the current law and the amendments which have been brought about and which will be incorporated in the course of this year. So in terms of our current law, we have a civil law procedure in terms of the Domestic Violence Act, and this has been considered on paper to be really progressive. But this good law is only as good as far as it is implemented. And a number of challenges have already been identified relating to its uptake, use, and implementation. The recent revision of the Domestic Violence Act, Criminal Procedure Act, and Minimum Sentences Act is aimed at providing a clear pathway of services and accessibility to services and tightening up of loopholes that were identified. The Domestic Violence Amendment Act and the Criminal and Related Matters Amendment Act were both passed by the National Assembly on the 10th of September and assented to by the President on the 28th of January 2022. This, however, does not mean that the law is operational yet, and we're looking at operationalization by the 30th of June of this year once the regulations and the directives are in place. So with regards to the Domestic Violence Act as it currently stands, and the response to domestic violence. Section 2 and 4 of the Domestic Violence Act provide that a survivor of domestic violence must be informed by the police and a clerk of the court of the right to lay a criminal charge for an offense. Bearing in mind now that domestic violence per se is not an offense. And it also seems to be a practice that is followed through by the police of not registering criminal charges for various reasons, but rather referring the victims to the court to enact or apply for a protection order. The Domestic Violence Act, being a civil procedure, does have a few offences in it, and these are contained in Section 17 of the Domestic Violence Act. And the offences are for non-compliance with the protection order, publication of information which identifies the parties, and a willful false statement in a material sense regarding the respondent's breach of the protection order. In other words, to get the respondent or the alleged abuser arrested. You will see that I have a number of items listed with asterisks next to them. And the reason for this is that the Amendment Act also brings about a number of offences. And these offences are for non-attendance or cooperation on the part of a witness, for non-reporting of an act of domestic violence against a child and a person with a disability or an older person to a social worker or the police. The Amendment Act brings about this obligation that's applicable to every adult person, that if you become aware of an act of domestic violence against a child or a person with a disability or an older person, in other words, a vulnerable person, you need to report it to a social worker or to the police. So this brings me to Section 3 of the current Domestic Violence Act. And in terms of Section 3, this provides that a peace officer may arrest without a warrant at the scene of domestic violence, where the offence contains an element of violence. The Domestic Violence Amendment brought about by the Amendment Act states that a peace officer who attends the scene firstly has a discretion to arrest without warrant if he suspects someone of committing an act of domestic violence, which is an offence or a breach of a protection order. And secondly, has an obligation, must arrest where there is physical violence involved. Now, this seeks to address the shortcomings which are hampering the police response currently. And you'll see that I've added the words at the scene and who attends the scene in inverted commas. And the reason for this change is that currently if the police go out to a scene, and the perpetrator runs away or hides next door or leaves the scene, the police officer no longer has the discretion of arresting the person without a warrant because the person has left the scene. So now by using the words who attends the scene, we've brought about the change that if the person has run away, the police still have the discretion to arrest or an obligation where there is physical violence. So where the criminal justice system has been engaged and a charge has been laid and the person has been arrested, the mechanisms of the criminal justice system kick in, and these provide for arrest, for bail, conviction, and sentencing. A number of amendments have been brought about to the Criminal Procedure Act, which aim to enhance the protection of a victim of domestic violence. And the first of these are an amendment to Section 59 and 59A of the Criminal Procedure Act. And this will now provide that no police or prosecutor bail may be granted if the person is in custody for a domestic violence offense or a breach of a protection order or offenses in Part 2 or 3 of the schedule. Just to put it into context, this includes assault for inflicting a dangerous wound, which wasn't previously there. So in these cases, a person will not get police or prosecutor bail. They need to go to court. A further enhancement to Section 59 is to include inflicting grievous bodily harm. So where a person has been harmed or threatened with grievous bodily harm, or is threatened with a firearm or a dangerous weapon, no police bail or prosecutor bail may be given either. So that discretion is taken away there. A further amendment to this section is a catch-all clause, and Parliament felt it appropriate to put this in place. And this is for any offence referred to in any law that criminalizes a contravention of any prohibition, condition, obligation, or order which is issued by a court to protect the person against whom the offence in question was allegedly committed. So this is a broad catch-all phrase. In those circumstances, the person will also not get police or prosecutor bail. In terms of Section 60, the amendment to this, which relates to providing bail in court, provides that the court must consider the view of the person against whom the offence in question was allegedly committed regarding his or her safety. It also considers factors such as the degree of violence used, threats of violence, any resentment harbored, the disposition of the accused to commit domestic violence related offenses or a history thereof while released on bail. And there's a number of other factors as well. So the court needs to consider all of this before considering bail. If the bail is unopposed, then the court may only release the person on bail if it is in the interest of justice and the prosecutor has placed on record what the reasons are for not opposing bail. So this is another safety mechanism put in place to protect the victim of domestic violence. Section 60(11)(b), which is to be inserted into the Criminal Procedure Act, also places an obligation on the accused to inform the court if an interim or final protection order for domestic violence has been issued. If there is no protection order that has been issued, the court then, if it believes that it's in the interest of justice to release the accused on bail, must issue a final protection order in favor of the victim of domestic violence. So the person doesn't have to go and apply separately. The bail will issue it there and then if the person is released on bail. In terms of the bail conditions, the conditions are also being augmented. Once a person breaches a protection order or poses a threat to the safety of the victim, the bail will be revoked. There are a number of additional court procedures too that are aimed at ensuring that it is less traumatizing and more manageable for a survivor of domestic violence to be in court. And that is Section 158, which allows for evidence by way of CCTV or similar electronic media. And that would be within or outside of South Africa. It could even be over a medium such as we are doing this morning over Zoom. Another amendment is an amendment to section 161, which provides for allowing for gesture language, demonstrations, and non-verbal indications where oral evidence is hampered. And then section 170A has been augmented to allow for an intermediary in these specific cases if the person is appearing in court and it would cause undue psychological, mental, or emotional stress or trauma. Section 299A is also amended to provide the survivor of domestic violence with a right to make representations if the person is considered for parole or correctional supervision. But this is only in the case where the sentence has been for longer than 7 years. It's also quite significant that the Minimum Sentences Act has been augmented and that the sentence for murder and rape of a person in a domestic relationship is now life imprisonment. The sentence for assault with the intent to do grievous bodily harm is 10 years for a first offense, 15 years for a second offense, and 20 years for a third offense, or third or subsequent offense. My apology, the presentation seems to be jumping a bit on my side. So the next question is whether the current criminal law response is adequate in dealing with domestic violence. As I said previously, we have no crime of domestic violence. In the words of Lisa Fetton, instead we have multiple forms which are captured across a range of different categories of criminal offenses, such as assault, either common assault or the intent to do grievous bodily harm, pointing of a firearm, intimidation, rape, or attempted murder, and there's a number of other charges too. We have a range of common law crimes already in place which are not specific to domestic violence, and these are murder, theft, malicious injury to property, and housebreaking, and a range of other offenses. We have a range of statutory crimes which are also not specific to domestic violence, and these are littered across the Criminal Law Sexual Offences Amendment Act of 2007 and also the Children's Act of 2005. With regards to the data collection, the police over the past 2 years are providing crime statistics which indicate that domestic violence is a causative factor in the crimes of murder, attempted murder, and assault. So they have started capturing and reflecting that data, which is seen as a barrier. There are a number of identified barriers though, and these barriers are that there are perceptions that domestic violence is a private matter, and this seems to persist. The police seem to be discouraging survivors or their families from laying criminal charges for various reasons. And then crimes are not treated the same as violence between two unrelated people. So this brings me to our third and final question here, and that is there a need for law reform or non-legislative change to address implementation problems? If I reflect back on the sexual offences report by the Commission in 2002, you would have seen that there's non-legislative recommendations allowed for in this process. And this provides us also with an opportunity. One of the non-legislative recommendations allowed for in that report was the blueprint for the Thuthuzela centres. So the solution that we come up with does not necessarily have to be hard law reform. So if one looks at the civil law process as it currently is and looks at the Domestic Violence Act and the proposed Amendment Act, you will see that the approach seeks to recognize the autonomy of adult victims of domestic violence by providing them a choice or an alternative. But the question is, does the Domestic Violence Act approach an underlying philosophy of dealing with family violence outside of the criminal courts undermine its overall value? Or does it respect the complexity of such relationships where the victim may wish to end the violence, but not the relationship? There are a number of other questions, and I'll just list a few of them. One is that, is domestic violence treated as less serious than other violent crimes when charged or where there is no charge? Does it allow abusers to escape criminal liability? In other words, does it decriminalize the problem? being mindful too that reporting may place the person reporting in greater danger and at risk of elevated violence requiring a more serious response. When one considers the withdrawal of criminal charges by victims, one also has to be mindful of the personal structural barriers which result in the withdrawal of charges. The criminal sanctions that are issued often do not bear relation to the future needs of the victim. For example, employment, housing, and food. And at a very basic level, if one looks at the Maslow hierarchy of needs, if you're removing employment, housing, or food, that's a very real risk to the person's well-being and of the children. So a person may then withdraw charges. And then one needs to ask then, if we have a no withdrawal policy, would this then not place victims at greater risk? And one needs to ask whether a clearer pathway of services would not provide adequate recourse. So this brings me to the domestic violence offense itself, and just looking at the nitty-gritty of whether one needs one offense or new related offenses. And within the next 1 or 2 slides, I'll just quickly relate one example of a manifestation of domestic violence, which is more and more coming up in research, and that is strangulation and choking. When one looks at an act of strangulation or choking, there are a number of criminal charges that may be used, and that is assault with the intent to do grievous bodily harm, attempted murder, or murder. Mostly, however, we're looking at a charge of common assault. There is no indication, though, that the assault is in the context of domestic violence, and if it's not recognized or detected, there will be no charge. Now, in 2004, from the San Diego prosecutor's office, they were alerted by 911 response teams that they were coming across a number of cases where there were angry events, where minimum pressure was used, and the victim was found unresponsive within 3 to 5 seconds of having pressure placed on their necks. Thereafter, they seemed to be confused and not understanding what had happened to them. But after repeat calls, they realized that along the trajectory, the final call would be for a fatal call. So the prosecutor's office started investigating when one should actually intervene in this trajectory of domestic violence. So based on research, it's been found that choking, smothering, or strangling are risk factors in fatal outcomes of domestic violence and have serious negative health outcomes immediately or sometime thereafter. Evidence has shown that there's neurological and psychiatric symptoms, sometimes memory loss, anxiety, PTSD, stroke a few weeks after pressure being placed on the neck, or even seizures. I recently had the privilege of attending training given by a neurotrauma specialist, Dr. Lewis, and he's a clinical neuropsychologist in Florida, and I thought I would just add it in here for interest's sake. And he has studied 4,000 women who were strangled in the context of domestic violence. And he found that there are underlying neurocognitive symptoms which are mistakenly viewed as solely psychological trauma and psychiatric disorders. So, for example, if the person is brought to court, they may be forgetful or disorientated or not understand what actually happened to them. In the context of the United States, it has been found that there is an alarming rate of domestic violence and co-occurring substance use disorders, 70 to 90%. And I think this is actually quite significant. He also found that in domestic violence and substance use disorders, women have a 90 to 95% incidence of neurotrauma events from concussion or hypoxia, but only a 1 to 2% rate of early identification. So by the time it comes to the attention of the courts, a lot of damage has already been done. Neurotrauma, he says, can mimic psychiatric disorders, although often both are present due to the stress of the domestic violence, but the neurotrauma events are often overlooked. He has stated that domestic violence, in domestic violence, you have concussive and hypoxic events, and that one must bear in mind that not only in America, But overall, in terms of domestic violence, 90% of the injuries in domestic violence are to the head, neck, or face region, which presents as neurotrauma. So in his area of Florida, they have just promulgated what they call Jordan's Law. And this law was sadly brought about by the death of a 2-year-old child, because one must understand that any injuries to the facial structure, the brain is behind the facial structure. And on this little child, there were indications of trauma around his lips, and he'd been placed back into the care of his mother, and she subsequently murdered him. And what they have done now in crafting this law is that they've mandated training to child welfare organizations and to law enforcement and judgments on head trauma and brain injury in children under the age of 6. You may also have heard of the social media influencer Gabby Petito. And in her case, her death has been found to be caused by strangulation. And it had happened a number of times, because strangulation happens in multiples, not just ones. And her family and friends have indicated remorse at not intervening at an earlier stage, not thinking it was significant enough. So in this context, the United Nations Women have recommended a specific penalty for strangulation in domestic violence as a standalone offense. What you will see, what makes it particularly difficult and why it is often not charged as assault, for example, on its own, is that it characteristically does not leave marks or signs, even when it is life-threatening. So in some jurisdictions, comparatively, they have specific offenses with higher maximum penalties, and this is in the United States, Australia, and New Zealand. The most recent amendment of the law has been in New Zealand, where they have a general offense of strangulation or suffocation with a maximum penalty of 7 years. Within the first 3 to 4 days, I think, of the operationalization of this offense, they had 200 to 300 cases being brought forward, because people are just not aware that strangulation has those negative effects and long-term effects. However, in other jurisdictions, there is no distinct offense, and that is in Canada and the United Kingdom. However, it's important to note that in England and Wales, there's been a renewed call for a freestanding offense. A recently released study of a number of women from the years 2000 to 2018 found that 6 out of 10 women that were killed in interpersonal violence were strangled. So one then needs to ask the question, do we need a specific offense, or will awareness raising on the dangers of strangulation and training in this regard be sufficient? And this is the basis of our questions that we've posed in the issue paper, and there are 7 questions. I'm not sure if I need to go through all of the questions, but essentially I think I've touched on most of them. And that is really around the area whether we do need to address the criminal law response or whether it is currently adequate. One of the things that I could show you in terms of the 7th question is just really whether we need additional sentencing or preventative measures. Something that has been touted is whether we need to have a register. If you are getting into a relationship with someone, do you need to know whether that person is a domestic violence offender, whether that person has got convictions of offenses against them? So those are just some of the questions that have been posed. And I can just request your submissions that to be made by the 28th of February. I've included my email address here and further contact details. Thank you.